The courts would be flooded with cases if they're going to try to prosecute people for saying outrageous stuff on Twitter.
Attorney John Archigo represents a high school student identified in court documents as AJB. In 2015, AJB created a fake Twitter account and over a few hours sent 40 tweets aimed at an autistic student, MB. Several tweets encouraged MB to commit suicide by drinking bleach, for example. Others hurled homophobic insults at him, what the courts called an unrelenting torrent of cruel tweets.
The tweets, we had arguments that that Twitter really is essentially today's modern version of a public square.
AJB was convicted in Scott County in juvenile court of felony and gross misdemeanor stalking and misdemeanor harassment. John Archigo appealed it all the way to the state Supreme Court.
If you're not threatening somebody, if you're just being offensive or saying some really outrageous stuff about people, that's not criminal.
In a decision issued this week, the Supreme Court threw out AJB's convictions. The opinion, written by Justice Paul Thiessen, found that parts of Minnesota's stalking and harassment laws were too broadly worded. The court left open the possibility that AJB could be found guilty of delivering a message with, quote, intent to abuse, if the juvenile court decides to go that route. Now, often when the people here at the Supreme Court make that kind of decision, lawmakers get involved. The action shifts over here to the state capitol, where they try to come up with a new law to fit the specifics of the situation. That's what happened in the revenge porn case. But even that law is now being challenged in the courts. In St. Paul, I'm John Croman.
Well, we reached out to the Scott County Attorney's Office today for some reaction to the ruling, but so far they have not been able to get back to us.